go and ascertain whether the copies that we have are true copies of the original. Once our secretariat has ascertained that fact, we shall use the photocopy that we have to make a determination.
Much obliged, Chair.
What's obliged, Chair?
Thank you.
Chair, yesterday morning when we were making our opening remarks, we did promise this committee and the entire people of Kirinyaga and the County Assembly of Kirinyaga, and more importantly, the Republic of Kenya, to whom pays all the revenue that this committee has the responsibility of oversight of. We promised them that today, at the fullness of time, at the close of these proceedings, we will be able to demonstrate with a lot of clarity and concise approach to things that the governor does not deserve to continue serving as the governor of Kirinyaga County. Question has been asked to witnesses. Have you seen the governor's hands in all these proceedings? Yes, we submit yes, that the governor's hands are so present in all the tenders that have been impunged, that the governor's officers, staffs are present, their hands are present, and that these officers are directly answerable to the governor. May I help the committee to draw this web? It is a web that begins all the way when the governor was the director at the treasury of IFMIS. It all began again by having Carilas Otieno, who appeared today as a witness, being an officer under the directory of IFMIS Treasury, who later becomes the chief procuring officer in the county of Kirinyaga.
Chairman, with
Further,
respect to learned counsel, this is not the time to tell the tale.
This is my tale.
Arilas Tieno stated that he worked at the Treasury. He didn't state where he worked.
This is my tale. Allow me to tell it as I want.
I will rule as follows. I think these are closing statements. So they are general statements. So we will pick whatever we can pick and leave whatever we can leave. So they're general statements, just like the opening statements, whereby you say anything without substantiating. We will be free with you, Mr. Ndegwa, but try and limit yourself within the scope of the case.
Thank you, Chair. So I said that Carilas Otieno, who previously worked at the Directorate of the IFMIS Treasury, where the governor previously worked before her appointment to the Ministry of Devolution, is now currently the Chief Procurement Officer in charge of Kirinyaga County. Suffice to note that this officer has been working in this county under the auspices of the governor without even having the proper certificates from his professional body. Question will linger. Why should somebody continue to serve? Where is the eye of the governor in all these? Is the governor in charge of the leadership in Kirinyaga County? We answer no in affirmative. How would a qualified person not holding a certificate of professionalism at that particular time proceed to execute such kind of important obligations and tasks? Is that the only way where the governor's hands are? No. You will need to move from that treasury, from the Directorate Treasury. You go all the way to the Devolution Minister. When she was the Devolution Minister, you have to mention all what proceeded, and this house is alive to the fact that this is not the first time a trial of this issue is being raised as against her. Then when you go to the Devolution Ministry, you will find Pauline Waiguru Kamau. Pauline
Yes, Senator Pauline.
I am worried if we are going to allow, I am worried if we are going to allow, with due respect to council, to allow council to start talking of things that were not articulated during the hearing about devolution, about IFMIS. Surely we cannot go that way. Chair, I ask that you guide him to make submissions on things that have been discussed before this house.
I directed Mr. Ndegwa.
Something, please. This is a quasi-judicial tribunal. This is an important institution. Let us not make a joke of it. If an issue was not raised here so that it could be controverted, how can it just be thrown out there? That it is unacceptable. How do you say Pauline worked in the devolution ministry? It is not an issue that was raised here.
Order.
Even if there is scope to talk generally.
Order,
Chair,
Mr.
Chair.
Order.
Will I then submit the submission?
Order.
If I may put an
Order.
chair only.
I think, order. Honorable Mazayo, you've been a judge before. When the chair says order, he means order.
I'm obliged.
I would ask the council representing Governor Waiguru to, first of all, respect the chair and speak through the chair.
Apologies, Chair.
Second, I still insist that, Mr. Ndegwa, you need to restrict yourself within the scope of the case. We shall not allow new allegations because we do not now have time to substantiate the allegations you're telling us. In your case, you never told us about the NYS, the IFMIS. Why are you bringing new things in your closing remarks? You need to restrict yourself to the scope of the case.
I'm well guided, Chair.
And I think because this borders on defamation, because we will not give you the liberty to say anything about Governor Waiguru, the full glare of the cameras. So if you continue with that trend, I warn you and I rule that I will rule you out of order and deny you an opportunity to make your closing remarks. Stand guided.
Chair, I'm well guided, and I also hope that I'm also protected by the chair, that I'm not under threat, that I'll be charged with libel or slander, because I am executing my civic duty. Okay, I'll adopt the line of my submissions which suits the council's interest. However, I'll submit that all what we are supposed to do is to demonstrate the nexus between the tendering that was done and Governor Waiguru vis-a-vis the charges that have been labeled as against her. Is there nexus? We submit yes, and that was held in the case of Mangi Wairia, that you must submit, you must create nexus, you must indicate how the governor is involved in all these. Then on that issue, Honorable Chair, I refer to section 30, subsection 3, which provides that in performing the functions under subsection 2, the governor shall provide leadership to the county executive committee and administration and on the county policies and plans. Of most importance is that the leadership is coming from the governor. And she's leading her CECs and leading the entire administration of the county. So her hands must be seen even in the procuring processes. That is the question of administration. Unless and until this law is repealed, this law creates a nexus between all that which takes place in the county. And hence the provisions of Article 179, which designates the governor as the chief executive officer of the county. So the question then that lingers, what is the coincidence that in all the tenders that have been impunged before this committee, we are seeing the hands of one Pauline Wairimo Kamau? Evidence has been laid before this committee that Pauline Wairimo Kamau does not even meet the minimum requirement to hold the position of the director. Evidence has been laid by the chair of the Public Service Board and confirmed by the CS, County Secretary, that prior to her appointment as the director of administration, she was in active capacity as the Governor Waiguru's public personal assistant. So the question is, what is the coincidence? What is the nexus? Does these things just fall in place? Were they by default or by design? Yes, we answer in affirmative, that this was by design. It was meant to have serious controls of all the tenders that Governor Waiguru has interest in. Why have we not impunged any other tender? We have only concentrated on these tenders. I submit thus that had it not been for the influence of Governor Waiguru to have Pauline appointed as director of administration, then should not have had the capacity. But it was so essential and so strategic to have Pauline as a director, so that she can have the ability and the capacity to sit and to have the locus standi to perform the acts that she has all performed. We move on. Wayne Geshira. Wayne Geshira is an advisor to the governor. If you look at the Transitional Authority, allow me to refer to it. Transitional Authority Advisory Opinion dated the 2nd of September 2013, and you go to the last paragraph, the one that was applied, you go to the last paragraph, paragraph 11, it says, the Transitional Authority, together with the Public Service Commission, in consultation with the Council of Governors and the Salary and Remuneration Commission, approved the creation of governor. Also, 3 support staffs was approved for each governor. The staff exist as advisors and not as executive or administrators in the hierarchy of the county governments. Underline the word executive and administrators, and also not. It is ultra-vires for these staffs to issue the abiding nature of shillings. What it was confirmed that the tenders involving velocity were also fictitious. The orders did not follow the law. The orders were not in compliance with the Public Procurement and Disposal Act. They were serious transgression. Who does this person report to? Who does Wayne Geshira report to? Wayne Geshira directly reports to the governor. The she never called for any. Then that means that idolence does not aid. She cannot be aided by her idolence. I submit thus that there is clear nexus as between these officers, the tenders impunged, and the governor. Evidence was led that this one officer, Pauline, does not even qualify to be appointed as a director. From a PA to a director, a re-advertisement is made in the national papers to suit the circumstances to find herself strategically positioned to siphon public money. Evidence was further led that tenders that were specifically reserved for specific groups, women, youths, and persons with disabilities, ended up benefiting one company. What is the nature of this company, Ever Trading Limited? The company is owned by a brother of the Chief Executive Officer Finance. This was confirmed in evidence. Is it by coincidence that one company, Ever Trading Limited, can have 3 tenders, and all these tenders are impunged, and the chair sitting in those tenders is Pauline? Was it by default that this company belongs to the chief campaigner of the governor, one Edwin Gishobindadi? Was it by default? Can we see the hands of the... Yes, I implore upon the committee to look at it from that perspective.
Yeah.
I further move, Chair.
Yeah, again, the issue of chief campaigner who did not arise in evidence, and now I am compelled, because Learned Counsel knows that he is abusing the privilege of this House. I am compelled to ask that you restrict that privilege so that appropriate action can be taken against counsel, or so that he can then be compelled to behave himself.
I'd like to get as follows. During cross-examination of one of the witnesses, the issue of chief campaigner was raised. And therefore, the council is in order to refer to it as to that particular issue, and to insinuate, though not substantively, that Pauline was the chief campaigner. So I think he's in order.
Thank you, Chair, for the protection. I move. We are saying that this was not by coincidence. This was a well-orchestrated and choreographed attempts, actually not even attempts, moves to steal from the public. We said yesterday that white-collar crimes is a concealed crime. One must have a toothpick for you to be able to pick the person who is actually culpable. Remember, it was mentioned in evidence that Governor Waiguru is not fond of signing any document. So members of the committee, when you retire to give your ruling and your findings, do not look at the hands of Governor Waiguru through a document that has been executed. You have to look and behold the executions of document, because that is her habit, not to sign any document that is committed in any manner. Evidence was further led that motor vehicles were purchased without following the due process. Guarantees were issued without following the due process. But honorable members, through the chair, what does section 102 of the Public Finance and Management Act provides? Again, when you retire, look at Article 103 of the same Act. Again, look at Article 103, Section 103, subsection 2N. Further, honorable members, look at Section 107, subsection 2(4). Again, further, look at those evidences as against the provisions of this law. The law is quite clear. Despite a refusal to admit that that was a bank guarantee, there was no another definition that was provided by the witness. Did that bank guarantee follow the provisions of the law? No. Was there approval of the county assembly? No. Does that undermine the county assembly? Yes. This amounts to a serious transgression of the law. All those tenders that have been punched, honorable members, you must read the requirement of Article 201. 201 provides that public resources must be utilized in a prudent manner. Public resources even include 1 shilling. It includes even 1 penny, as long as that 1 penny has come from the Kenyan. It must be utilized in the prudent manner. Do not look at the amount of the money that was actually lost. Look at the amount of look at the process in which this money was lost. For example, honorable members, I recall you to remember that there was an imprest, 2 imprests that were provided to us this morning. An imprest dated, a receipt dated the 17th of April, 2020. What was the purpose of that receipt? The receipt was returning the money. Where was the money domiciled? The money was domiciled in the governor's account. Was that confirmed during the hearing? Yes. The chief officer confirmed that he received the money from the governor. Did the governor therefore draw personal benefit from that money? Yes. For 4 months. Why was she holding Kenyans' money? Is she authorized to bank on behalf of Kenyans? Does the governor become the central bank of Kenya? That is a serious transgression of the law. Remember, honorable members, Rule 93. Rule 93 on the PFMA Act requires that there must be a surrender if a journey or a travel has not been taken. Did that take place? The law says it must be done within 7 days. This is done after 4 months. And 4 months after the governor knows that a motion has been filed to impeach her on the question of abuse of office. Does that demonstrate the question of abuse of office, honorable members? We answer in affirmative, yes. It demonstrates abuse of office. Did the governor have a personal gain and personal benefit from that money? Yes, she did. What was she doing with it for 1 month? For 4 months? Honorable members, as I sum up my submissions, I urge you to look at the transgressions that have been done on these Kenyans. Honorable members, the law has been transgressed. We have the duty under Article 3 of the Constitution to protect the Constitution. And not just to protect the Constitution, even to protect any other law that emanates from the Constitution. Any transgression on any law is a transgression on the people of Kenya, and it's a transgression on the Republic of Kenya. The members of the County Assembly of Kirinyaga County, 23 out of 33 returned a verdict. There was not even a favorable vote in favor of the governor during the impeachment. Therefore, honorable members, the people of Kirinyaga exercise their sovereignty through the elected representatives under Article 1. Further, members, Article 10 requires that there must be accountability and transparency. Transparency is transparency in the sense that when you fail to go for a journey, you must be able to refund public funds. It is on record that this House has that habit, and it was on record that the Honorable Speaker of the National Assembly actually commanded members of the National Assembly to refund the money when they failed to go for the travel in the US during this COVID. Is Governor Waiguru exceptional? Governor Waiguru is not exceptional. The law says that we are all equal before the law. She should therefore not have any favor. She should not have any treatment that may mean that the law favors her. She is under armpits of the law. She has no protection of the law. The law only protects itself. The law protects the fidelity of the law. Any person who initiates any action that amounts to the infidelity of the law is an enemy of the law. An enemy of the law is an enemy of the people of Kenya. Honorable members, as I sum up, you'll ask whether the county assembly has made out its case. We answer yes. Even where we had chief officers, for example, in the Department of Water and in the Department of Health, we have seen the hands of the chief officer finance executing all the necessary documents, the chief officer finance executing on behalf of the officers. On questioning, we were told that those offices were not vacant. Was it by design? It was not by default, honorable members. It was by design. On that one, honorable members, you are going to look at section 46 of the Constitution, section 46, subsection 2 of the Public Procurement Asset Disposal Act. Honorable members, it was confirmed before this committee that even on matters as sensitive as health, the governor just issued what is called roadside declarations. Roadside declarations was a disease that prevailed, was a pandemic that prevailed during the regime of Moi. We thank the new constitution that we are removed from that regime, and the new constitution required under section 41 of the County Government Act that any meeting that the county executive sits to deliberate on, it must be put in writing. What did the county secretary say? The county secretary just feigned ignorance. Can the governor benefit from that ignorance? No. The governor cannot benefit from that ignorance. The county secretary was aware that you'd be confronted with such kind of questions. Even on what is on record in his testimony about the task force report, he cannot provide a minute for it. He cannot provide a cabinet position on it. Put to task to explain, he says the governor gave the directions. She gave the directives. Honorable members, we must protect our democracy. We must protect the democracy and the gains that comes with the new constitution. The democracy that is contemplated in the new constitution is a democracy that is under Article 73 of the Constitution. Article 73, 74, and 75 speaks to a leader becoming a servant. The Constitution says that we no longer have rulers, we have public servants. Has Governor Waiguru demonstrated that servanthood? The answer is no. She has not demonstrated that servant leadership. And is she supposed to benefit and given the benefit of doubt when she has serious transgressions of the law? She should not be given any benefit of doubt. Put to task the county secretary on the question of whether or not there exist minutes. He said no. That was affirmed by our witness. 2 CECs appeared before you, and they gave you a picture of how the county government of Kirinyaga is run. Who else can we believe other than the insiders? Who else can we believe to be the owner of the story other than the person who was there? Honorable members, as I sum up and rest my case, I beseech you to look at this case as one way of protecting democracy, one way of protecting devolution. And may you not forget that sometimes some jobs can become difficult. One can be looking for a lighter engagement. And that later engagement becomes as difficult as it is now. We are now in that situation where we were, that the duties have become more harder than expected. These are not lighter duties for Governor Waiguru. This distinguished assembly is well positioned.
That insinuation, again, is abuse of privilege of this house.
What specifically are you referring
The
to?
insinuation that Learned Counsel made, Chair, about lighter duty, and this not being lighter duties, and us being where we were.
I do not get the connection of lighter duties. Maybe you tell this house.
We let that one slide.
Yes.
But I believe we all understand what he was saying.
The chair does not understand what it means by lighter duty, so I'll just leave it the way it is. You have 5 minutes remaining.
What of the interruptions, Chair?
You have 4 minutes remaining.
Obliged.
Yeah.
So what are we saying, Honorable Chair and Honorable Members? The people of Kirinyaga County and the people of the Republic of Kenya have confidence in this committee. They have confidence that this committee will deliver justice. They have confidence that this committee shall look at the evidence that has been presented before it and not the individuals that have presented this evidence. This house will be on trial at the fullness of time to show cause whether they actually protected democracy and protected the rule of law and protected the whole aspects of devolution. Protecting devolution is not protecting individuals who have questionable characters within devolution. Honorable members, when you retire, kindly look at your roles under Article 96 of the Constitution. Finally, members, how many times can one commit transgressions and get away with it? I rest my case.
Good. I now call upon the council representing Governor Waiguru to make closing remarks.
Honorable members, thank you for the opportunity. We'll break it into three. I'll start with the first short part. My learned friend has clearly stated that what we seek before this honorable house is fidelity to the law and the Constitution. The High Court, in its description of this honorable court, has in very many decisions held that this honorable house is the defender of devolution, defender of county governments and counties, and that has been explained based on the very many provisions of the Constitution. And one obligation that is placed on this house is that in the case of Mwangi Wairia versus the Speaker of Muranga County, the High Court went as far as saying that this honorable court plays the role of the impeachment court. That is a very special position given to it. And it indicated that in that role, the Senate is expected not only to investigate the nexus of the allegations to the governor, it is also supposed to interrogate the entire process as it's carried through the county assembly to determine that not only was the Constitution complied with, but also the requisite requirements of natural justice were also followed through. Now, our submission in summary is that the House is faced with a motion that did not meet the constitutional threshold for the following reasons. One, the Constitution is very clear in Article 196(1) that the county assembly has an obligation to ensure that its processes undergo public participation. That is a constitutional obligation. The county assembly has confirmed that there was no public participation. The courts have made it very clear that with regard to the issue of public participation, and in that we have been able to indicate in the submissions that we have placed before the House, the written submissions which we rely on, that public participation is not usurped by virtue of representation. The public must be involved. And that is why the provisions of the County Government Act are very clear on citizen participation, and how it's supposed to be undertaken. That has been confirmed before this out, it was not done. Secondly, the Constitution is very clear that when allegations against a person that are going to have adverse consequences on them, pursuant to Article 47 and Article 50 of the Constitution, a person is supposed to have fair administrative action and a fair hearing. The requirements for a fair hearing have been set out in the Constitution. We have indicated for the fact that the people who moved the motion slept in the House so that they could go through with the agenda. It was very clear that they did not comply with Article 50 on impartiality. Secondly, the governor was not given a chance to defend herself and answer to the charges. So the question of fair hearing was also violated. Now, on the issue of threshold, Article 180 is very clear about threshold, and this House has rendered a number of decisions, which we have quoted in our submissions, on what that threshold entails. And one thing that has come out very clearly in the decisions of this House is that the tool of impeachment was not intended to be used for malicious purposes, but it was intended to facilitate good governance in compliance with the Constitution. And the question that is there is, have our friends complied with that? Now, the Court of Appeal in the case of Martin Wabora versus the Speaker of the Senate, which we have indicated in our submissions, clearly states that not only must it be shown that the proper procedure was followed, it must also be shown that the threshold was met. Now, the question that this House has to contend with, based on the motion that was placed before the House and which the governor has responded to, was any evidence adduced in that motion to substantiate the allegations made? And we are holding that no evidence was led to substantiate the same. And so to that extent, they became mere allegations. And the question that we are asking this House to ponder on is, can somebody be held culpable on the basis of mere allegations? And on that issue, I want to urge the House to consider a decision that we have quoted from the Supreme Court in the case of Ferdinand Waitito versus Evans Kidero, which I will read, which says, from the beginning, it is clear that the applicant is endeavoring to build a case on the foundation of a bare allegation. It is an allegation of corrupt conduct on the part of one judge, a judge forming part of a Supreme Court bench of 7 judges. And then it goes on to say, to conclude, that I have to state clearly that the applicant is bringing before the Supreme Court a case that lacks any legal foundation. And as the matter is not therefore properly before the court, I hereby find and hold that it is inadmissible as a cause in the Supreme Court's work program. And it proceeds to hold that mere allegation does not shift the burden of proof. And as I close on this issue, I just want to remind the court on the Supreme Court decisions in the case of Wetangula, Moses Wetangula versus IEBC, and Frederick Outa versus Gerard Odo, which you have quoted there, which have clearly stated, when it comes to matters of a criminal nature, corruption being one of them, the standard of proof must be beyond reasonable doubt. And the evidence must be credible, cogent, focused, and clear-cut. And we submit to you that no such evidence has been placed before you. And as we close, I want to just mention one issue that the Court of Appeal in the case of Martin Wabora versus Speaker of the Senate held. And that is the fact that when it comes to matters of impeachment, impeachment cannot be based on the political principle of collective responsibility. Evidence must clearly point and affix itself on the governor. Thank you.
Chair, with your permission, I'd like to make my presentations as I stand. Can I do that?
That is well accepted.
Right.
At least you've gone through the chair now.
I have learned my lesson, Chair. I'm a quick learner. Chair, I'll go very quickly on the issue of the grounds, and by starting by saying that a case was presented before the County Assembly of Kirinyaga, and an impeachment was concluded. That motion was then brought to this House with the grounds and the evidence. The responsibility of the motion mover and the county government of Kirinyaga is to prove that motion before the Senate. Now, let me give you the grounds that were alleged and the responses to them. Ground one, violation of the Constitution. There is no constitutional provision for the government to provide at all a state of the county address. There is a provision in the County Government Act. It does not say the presentation is to the County Assembly. That County Assembly provision is in the standing orders of the House. So if there's any violation, it is that the governor violated the standing orders. That is why you're being asked to impeach her. Number two, on Pauline and Wayne, what is there is salacious information. It is interesting, it's exciting. But look at it this way. Pauline Kamau was appointed pursuant to an advert by the County Public Service Board that defined her qualifications. This is an independent body. It then went on to interview her. It then went on to recruit her, and then decided at this point when it is politically convenient to say, oh, wait a minute, this was not our act, we were being pushed. Who will believe that sort of stuff? Number two, on the evaluation committees. The evaluation committees are ad hoc. Information was given here that actually Pauline and Wayne sat in a minority of evaluation committees. What my colleagues have done is they have picked the contracts in which these two sat and then said, impugn these ones, and then send the story that these are the only contracts that were impugned. But look at the contracts and look at the issues that were raised on those contracts. There is nothing significant in the allegations. The majority of them are about whether or not they complied with AGPO regulations. Now, you are representatives of counties. You know the sort of traders who trade in counties. They are small traders. They are not people with 3 years qualifications, audited accounts of 5 years. Most of them are youth and women companies. So AGPO requirement is the very essence of the success of the business environment in the counties. But what you are saying is making it as if it's evil to have an AGPO certificate. The truth of the matter that even for the open contracts, we give preference is given to AGPO companies. For all these companies, the AGPO certificates were presented. For EVA Trading, the one that became interesting about 3 contracts on water, because all of them are provision of water. The AGPO certificate was never an issue in this complaint. Otherwise, it would have presented the certificate. And in fact, the certificate is available and will be presented to the committee and to my colleague, and they can confirm this is a government certificate. We are not the ones who produced it. On the issues of the two Gishira, and they sat in committees of either 3 or 5 people as one vote. So at any point there were minorities. So why is it who are so powerful that all the other committee members, are not able to raise issues, but these people, they never sat together in a committee of 2 where there were majority. So that's why I said these issues are salacious and interesting, but they actually have no foundation. Let me also say that we must keep saying, even though my learned friend would like to keep saying there's a hand in the cookie jar, honestly, that is unfortunate, because if you're going to make an allegation of the nature of corruption, surely, at the very minimum, show that there is loss, so that there is movement of the money from somebody, so that after that contract was given, money was moved to somebody. You can even then show that that person is associated with the governor. There is even no such allegation. All we are saying is a contract X got a contract for 13 million. So that is corruption, and the governor, and this Senate is supposed to believe that story and impeach the governor and send the governor. It is unfortunate and demeaning of the Senate. Now, the issues on the tenders largely revolve around qualification of tenders. In none of these tenders was an issue raised by the losing bidders. Has this House now been converted to the Procurement Regulatory Authority to investigate tenders? Is this House going to be pushing the agendas of contractors who lost tenders? It is not acceptable unless there is almost criminal activity to be shown in the process of evaluation those tenders. Let me mention one contract that went over and over, Velocity. Again, unfortunate. There is no question that those documents relate to one company. I, for example, prepared the response of the governor. I wrote Velocity in all those documents myself. I actually did notice that there's a difference in the spelling myself, because it's not the sort of word. Generally, unless you really look, you read velocity. That's a normal thing. So these are very typical sort of errors that happen. And you can see that the critical documents in this process, the tender award, the contract, even the payments are to the same company. So this insinuation is just interesting, salacious, rumor-based, but it actually has no foundation in law. Honorable senators, there are several allegations which were thrown on the motion, but were never even, there was no evidence presented. There's an allegation that a company was paid 8 million shillings and it did nothing. Not a single shred of evidence was presented. It was just thrown there. There are allegations that were given on that the governor did not travel for 13 trips. 13 trips were listed that the governor did not travel. We have shown that in 3 of those proposed payments, there was actually nothing like that. The county assembly actually just created. Remember when I asked for the evidence, they said the chief officer would come and present that evidence. Honorable senators, did you hear that evidence of that money? You did not hear it because it does not exist. On the 8 trips that the governor traveled, the original passport, as I have said, we're offering to give it to you so that you can see it. The reason it's being asked for is if it's to create a narrative, which is very, very unfortunate for this house. Issues that were raised about coffee, Kirinyaga coffee, these issues were not raised in this motion. If these issues had been raised, we would have presented a whole dossier about how it happened that the governor decided at the last minute to cancel this trip. And that was because it was going to be a loss for the county, because they found out at the last minute that their partners in the US expected the county to spend money on that launch. Initially, the assumption had been that they would run the cost. So at the last minute, the governor had to make a decision. Do you continue to expend more, or do you cancel, even if it inconveniences people? If that had been raised in the beginning, would have presented bundles of evidence to show. But this was the essence of ambush. Present evidence at the last minute so that it can be answered, and then you stand and say, oh, we have proved there's been theft. Which theft? Which laws? Which of these contracts has been said not to have been performed, to have been exaggerated, for money to have been paid to a third party? Not. You have set on impeachment motions in this Senate. What is the evidence that has been presented to you by the time you get to the point of making a decision on impeachment? It is not rumors and allegations without evidence. A motor vehicle, honorable senators. How does even an allegation like that find itself in an impeachment motion? This is a vehicle that was whose budget was approved by the assembly twice by the same assembly. The only difference was that money was moved from one account in the county to another one to arrest a crisis caused by the advice of the controller of budget. There is no allegation that the governor took any money. There is no allegation the vehicle was appraised. It was bought under a framework contract. And yet, it was presented here for salacious reasons to say that, money was lost. It is unfortunate. KIDA. KIDA is the allegation about the payment of salaries. And in the documents we have presented to you, you will see there is a formal letter from the SRC on how board and staff members are to be paid. It is there in the documents. That sort of allegation still finds itself in the motion against the governor. That is what I'm saying about the frivolity of this motion. It is intended to achieve a political purpose. Even the statements that are made in support of it are not based on law. They are intended purely to achieve a political aim. It is meant to defame and harass the governor. On health. Honorable senators, the truth of the matter is there are challenges in the health sector. That is the reality. That is not unique to Kirinyaga. That is not unique to one county. Some counties have more challenges than others. In respect of Kirinyaga, a strike happened. There were political issues, as evidence was given. The governor is not the sole player in the process of provision of health services. I can give you 2 examples. In the current budget, because I think that it was one of the documents that was presented to you. In that process, the monies allocated to health has been reduced and given for ward offices. The county assembly has refused to approve the appointment of members of the public service board. So the county government cannot employ doctors. So that is the crisis in which the county public service board has no quorum. That is the sort of problem that is created by the assembly, and then it is thrown to the governor. Evidence on that issue was pushed by people who are clearly pushing an agenda. Even on a simple issue about whether they know each other and whether they work together, they all changed and said they don't, when they realize that there's going to be a problem because they can be seen to be working in concert. These again are people pushing agendas. Anybody can visit Kirinyaga County at any time. We invite even this committee to take 2 hours and go there and establish whether the story given on dilapidated services is whatever by the facts. It is not. What do I want to say finally? Is that we have no problem with the oversight role of the county assembly. But if the oversight role and the impeachment is going to be used as an avenue for harassment, for bullying, for punishing governors because they don't bend over backwards, that will not be acceptable. And honorable senators, you must not allow it. If there is evidence to show that there has been breach, we would say the Senate can exercise its powers as it is allowed by the Constitution, but it must not be utilized for collateral purposes. I will yield the last 10 minutes of my presentation to the governor to make her final comments.
Honorable Senators, allow me to begin by expressing my gratitude to this honorable committee of senators for your time and passionate engagement in the various issues raised over the last 2 days in relation to the matter before us. You have kept an open mind as we interrogated the evidence brought before you, both in support of the allegations made or in the rebuttal against these allegations. The responsibility now, therefore, lies upon this committee to determine whether the impeachment motion was the way to go in addressing the issues raised by the County Assembly. Honorable Senators, you can, however, having listened to the presentations made by the Assembly, bear me witness that they mainly involved emotional and contradicting witness statements that were neither supported by any evidence nor fully substantiated by facts. Case in point, you heard about the evidence that there was no 150 million contract paid to Velocity Company, neither did they evidence the invoice of 30 million paid, passionately alleged by the MCAs in the impeachment motion. You clearly heard out of the 10 million shillings claimed to have been sent to my account. 4.6 million was completely fictitious and non-existent figures, which was never sent to my account. Further, honorable senators, you heard that in 2 of those trips that I'm alleged not to have gone, the leader of majority was actually present in those 2 trips, and even photographs as shown today. You heard of the witness claim that our health facilities are dilapidated to the point of all of them having been infested by snakes. This is in contradiction to the national body, the Kenya Medical Practitioners and Dentists Board, and others who gave the hospital a clean bill of health after we resolved the issue of the health crisis. She cited the lack of autoclave machines and incinerators, which the members of the County Assembly so graciously allocated budgets in May last year and were purchased. Honorable Senators, the County Assembly has also failed to demonstrate to this committee how a public participation process on the impeachment process was conducted. My lawyers have dispelled the false allegations that form the basis of my impeachment, and we have seen that they are an affront to the impeachment process as described in the Constitution. The issues raised could have indeed been clarified through routine inquiries. The Assembly has also failed to prove that any of the tenders mentioned in the impeachment motions were irregularly awarded or that the county incurred any financial loss as a result of the said words, let alone proving how the governor was conferred any personal benefit. We have been able to table before this committee evidence on various correspondences between the county government and the county assembly, and therefore dispelling the claims that the executive does not furnish the assembly with relevant information on implementation. I reiterate that these kinds of falsehoods are do not only demean the legislative arm of the county government, but are proof that the motion was only seeking to malign my name with an ulterior motive by the MCAs. The Assembly even failed to interrogate the public procurement procedures which could have duly informed them that it is within the provisions of the law to purchase the governor's vehicle from the manufacturer that supplies government vehicles under a framework contract. Honorable Senators, so far we have been treated to innuendos, trivialities that do not meet the threshold of gross violation of the Constitution, hence meriting an impeachment. As I stated in the beginning of this hearing, this impeachment motion has consumed a lot of valuable time that could have been used to work for the Kirinyaga people. The negative impact of this process cannot be underestimated. I therefore call upon this committee to thoroughly scrutinize the evidence submitted here and disregard any unsubstantiated claims. The precedent that this committee will set will be a point of reference in future impeachment processes, and it is therefore expected that the decisions taken by this committee will not come back to haunt this House. All eyes are on this committee to make the decisions that are beyond reproach and that will stand the test of time. I urge the Senate to ensure that the outcome of the proceedings will serve justice to the residents of Kirinyaga County who deserve every effort of the elected leaders in accomplishing the development agenda of the county. In conclusion, Honorable Senators, seeing that there is no evidence to substantiate the allegations brought against me, allow me to tell you why I'm truly here. As the elected governor of my county, some national issues have fallen on my shoulders, particularly those pertaining to the equitable and fair share of national resources to the people of Kirinyaga. This has meant taking political decisions, including to support His Excellency the President in his BBIA initiative, which I believe is in the interest of Kirinyaga and all Kenya. Honorable Senators, my stand has made me enemies with people of deep influence and deep pockets, inside and outside my county, which is a matter of public record, resulting in endless attacks on my person because of my support for the BBI and the handshake. But, in the words of the famous Pan-Africanist Frank Fanon, I have no regrets, for he said, each generation must, out of relative obscurity, discover its mission, fulfill it, or betray it. To those that have conspired with those forces to wrongfully impeach me, I forgive you. And I say to you as I close, in the words of the great American female poet Maya Angelou, Kirinyaga people will forget what you said. They will even forget what you did, but they will never forget how you made them feel, and neither will I. That notwithstanding, I forgive you. Outside conspiracies visited on us, with the help of a few local leaders, has brought shame and humiliation to us at home. I pray that it should never be allowed to happen again. Thank you, Honorable Senators.
Good enough. Honorable Senators, ladies and gentlemen, I think that brings us to a close to this session and to the entire case. I want to take this opportunity, first of all, to thank the parties led by both legal teams for eloquently arguing out their case. I also want to take this opportunity to thank the County Assembly members for undertaking their duties and their constitutional mandate as enshrined in the Constitution and further enshrined in the County Government Act. I also want to take this opportunity, honorable members, ladies and gentlemen, to thank all the witnesses who appeared before this committee for performing their civic duty. We have had both parties, and I must admit with all honesty that we have drilled deep into the matter before us. We have extracted enough content and or information that will guide this honorable committee come up with a concrete determination that will be referred to by the coming generations. There has been a wide speculation that this committee has already or has an already predetermined outcome. I want to state clearly that I have a lot of confidence in my members. In this committee, we have a galaxy of professions and professionals. We have doctors, we have Dr. Mbito, whose integrity cannot be questioned. We have retired judges, or judge to be precise, my good friend Judge Mazayo. We have lawyers, Honorable Pareno. We have former MCAs, like Honorable Beatrice Kwamboka and myself, proudly a former MCA. We have seasoned politicians. We have farmers, like Honorable Mpayai. We have career women, like Honorable Beth Mugo and Honorable Halake. We have fishermen, like Honorable Moses Kajwang, and I have a lot of confidence that these are men of integrity and that we are going to give a just ruling. And we also have footballers, like Honorable Anwar. We play in the same football team. He is my captain. And I said seasoned politician like Honorable Kidiomi. So, honorable members, ladies and gentlemen, I want to assure the public that we are going to retreat and make a fair ruling based on the evidence that has been adduced before us. We're not going to use information fished out of the presentation that we've had. We are going to stick to the evidence that has been adduced before us. And as you have all seen, we have the Speaker of the Senate has already gazetted Friday afternoon, 2:30, a special sitting that we will be expected to table the report. So I would like to invite all Kenyans to anticipate a fair ruling on Friday afternoon, and I believe by then we shall have come up with a ruling. Lastly, I want to appreciate the press and the media in general who have gone out of their way for the last 2 days to ensure that these proceedings are covered live. And I feel guilty that my committee did not offer lunch to the media personnel. I want to assure them that next time I chair such a committee, I'll provide lunch for you. You'll have to forgive me. I've kept you here for 2 days, and we were unable to provide lunch and basic meals for you. But that is a correction that, as the chair, I undertake that next time we shall be making such recommendation that it is important for us to acknowledge that the media is part and parcel of this proceeding. Otherwise, honorable members, I want to thank you for your commitment and your patience. And just to ask God, finally, to give this committee overwhelming wisdom as we retreat to do our report. And I believe our good Lord has heard our prayers. Thank you, and may God bless you. Yeah. Yeah.
George, I'm ready. Come on, what? I'm on my mind.
Go to 20 with the councils to verify the passport.
Oh, you go. Then you should go to boxes.
The date. Look, someone with the date. In potential. Is that which document has it?
Thank you.
So, let's see.